3 to 5 ounces, I don't remember.
To go from misdemeanor possession to felony possession, or I'm not sure. I don't recall.
But
I should know it.
I'm more than willing to negotiate on that.
Put it in comparison. Typical arrest for possession, a 1/4 ounce bag, and we're looking at 8.5 times.
Well, I would be glad to have an amendment to lower that amount.
And one other thing from my other greatest concern, and I appreciate your willingness to work that out, is on page 9, and it talks about the presumption. Take DUI, for example. You know, just to kind of put it in comparison, if someone's 0.08 or above, they are presumed intoxicated. It's a rebuttable presumption, but that falls back to the defendant to rebut that. This legislation is just the opposite. The presumption is that you are using it for legitimate purposes, and law enforcement must rebut that presumption. And that's, do we do that anywhere else in statute? And I just think that's it's a precedent.
Good point, but let me remind you that the people who would be covered under this would have an ID card from a physician, that they would show the law enforcement officer that they can use this legally, and you know, so I think that's a little bit of difference, and there is a huge difference between the effects of marijuana versus alcohol.
Listen, I agree with you on that. I mean, my years in law enforcement, both driving while intoxicated, but you know, the guy that's 2.5 BAC drives 100 miles an hour down the road. The guy on marijuana does 2 miles an hour down the road.
Using this are not going to be right. These are people in severe pain, recovering from, you know, cancer. It's not like they're going to be zipping up and down the highway.
Right. I do think you actually made an argument for me as far as where the presumption should be. If they have the card, if it's approved by law enforcement, that it should be presumed that it's obtained illegally. If they have the card, then you rebut the presumption. This legislation is flipped the other way, where it's presumed that officer would have to prove that it's not being used for medical purposes. If we could flip that presumption, I think that goes a long way.
Sure.
Thank you for taking my comments.
Mr. Roberts.
Thank you, Mr. Chairman. Representative Todd, I want to commend you for bringing this, and as you were saying to start with in your opening statement, it brought back a lot of memories. Unless people have gone through this and had relatives that were dying of cancer and taking chemotherapy and radiation and all that, you know, you just don't understand. I come from a rural county, and years ago, I guess we were proactive and we were ahead of the law on this. But what we did there, if a family member would come in, talk to the sheriff and the district attorney and a judge, the sheriff would provide the marijuana for them. So we've been doing that. We did do that. I'm not sure it's going on now because it makes too much common sense. There's a book out one time that says the death of common sense. Sometimes, you know, I think we do that. But I have a law enforcement background, and I see that I can, you know, to make it to where it's not abused. But I'm for helping people who, for medical purposes, if this will help, then I think that we have responsibility as the state government to do that.